She has sold over 100 million records. She has held an Academy Award in her hands. She has stood on stages in front of hundreds of thousands of people and made them believe for 3 solid minutes that time itself had stopped. Cher is not a career. Cher is a monument, built over 6 decades, one reinvention at a time, out of nothing but stubbornness and the refusal to be told what she could not do. But behind that monument lies a story not glamorous, but staggering in its legal and personal complexity. A story that stretches from a divorce agreement signed in 1978 to a federal courtroom in Los Angeles in 2026. A story about a widow who said she could take back what a judge had already given. A story about 50% of something that was worth fighting for across 5 years and more than $1 million in legal fees. And a story about what it costs, financially, legally, personally, to hold on to what is yours. Because on July 17, 2026, a federal judge confirmed what Cher had argued all along. The royalties were hers. The agreement was unbreakable. The attempt to void it had failed. And then, in the same breath, that judge told her she would have to pay the bill herself. Every cent of the $1,023,605.30 she had spent winning. She won. She pays. She keeps going. If Cher has ever made you believe that it is never too late to fight for what is yours, hit like as tribute to the woman who proved it in a federal courtroom at 80 years old. It is extraordinary when the beginning of a legend is marked not by wealth or privilege, but by a girl with nothing in a border town at the edge of California who decided very early that the world was going to have to get out of her way. Sherilyn Sarkisian was born on May 20, 1946, in El Centro, California, a small, sun-baked city pressed against the Mexican border, temperatures routinely above 100 degrees in summer, a place where very few people arrived dreaming of fame and even fewer left to find it. Her father, John Sarkisian, was of Armenian descent. He was largely absent. By the time Cher was old enough to form a memory of him, he was already gone. A recurring disappearance that would define her early childhood not by the presence of a father, but by the permanent awareness of his absence. Her mother, Georgia Holt, was of Irish, English, Cherokee, and German descent. A woman who was beautiful, restless, and relentlessly trying. Georgia married 8 times over the course of her life. She worked as a model and an actress, chasing her own version of the dream while raising a daughter who would eventually catch it first and hold it longer than anyone around her could have predicted. Cher has spoken about that childhood with a particular kind of directness. Not bitterness, exactly, but the flat clarity of someone who stopped looking for a softer way to describe it a long time ago. There was no money. There was instability. There was a mother who loved her, but was not always there in the way a child needs, and a father who was almost never there at all. By the time Cher was a teenager, she had already lived in enough places, attended enough schools, and watched enough of her mother's reinventions to understand something essential: that a life could be rebuilt from almost nothing, and that the rebuilding was not a tragedy. It was simply the work. She was, by her own account, a poor student. Dyslexia made reading a struggle in an era when dyslexia was not diagnosed, only punished with low marks and lower expectations. What she had instead of academic confidence was something harder to teach and impossible to fake: a physical presence, a voice that even at 16 had weight to it, and an appetite for attention that was not vanity, but something closer to survival instinct. She knew, in the wordless way, that some people simply know, that she was meant to be seen. At 16, she left. She moved to Los Angeles. Not with a plan, not with money, but with the absolute certainty that El Centro was not where her story ended. She took acting classes. She moved into an apartment with a girlfriend. She worked where she could. She was a teenager in one of the largest cities in the world, with no family money behind her and no connections in the industry she intended to conquer. And then, in 1963, she met Salvatore Philip Bono. Sonny was 27. Cher was 16. He was working as a promotion man for Specialty Records, moving through the edges of the music industry with enough energy and ambition to make up for what he lacked in conventional talent. He was not a great singer. He was, however, a great believer, and the first thing he believed in, with a conviction that would shape both of their lives for the next decade and a half, was Cher. She has described that first meeting in various ways over the years, but the emotional core of every version is the same. She was a girl who had never been taken entirely seriously, and here was a man 11 years her senior, who looked at her and saw exactly what she was. Not what she might become with the right guidance, what she already was. The voice, the face, the stillness that could fill a room. He became her manager. He became her collaborator. He became, in 1964, her husband, in a ceremony so informal, so far from the white dress cathedral version of matrimony, that it barely registered as a legal event. They were married, they were broke, and they were about to change the sound of an entire generation. It is a particular kind of irony that the partnership that would eventually end in a courtroom battle spanning 2 different centuries began not in a boardroom or a lawyer's office, but in the back rooms of a record business in 1963. They started as Caesar and Cleo. That detail is almost always lost in the larger mythology. The wigs, the bell-bottoms, the television variety hour, the cultural shorthand that the name Sonny and Cher eventually became. But before any of that, before the matching outfits and the comedy routines and the Saturday night institution, they were 2 nobodies performing under borrowed names on the edges of the Los Angeles music scene, trying to get someone, anyone, to pay attention. Someone did. In 1965, Sonny and Cher released I Got You, Babe. It reached #1 in the United States and in the United Kingdom. It sold over 4 million copies. It was played on every radio station in the country and adopted almost instantly as a generational anthem. The sound of young love that was defiant and tender at the same time, the sound of 2 people who had chosen each other and were not particularly interested in what the world thought about it. Cher was 19 years old, Sonny was 29, and overnight, they were famous. What followed was a run of success that, by the standards of the mid-1960s, was remarkable. The Beat Goes On, Baby Don't Go, Bang Bang, which Sonny wrote for Cher, and which became a solo signature that demonstrated something the duo format sometimes obscured: that the voice, the real instrument in this partnership, was hers. She could sing, not in the trained conservatory sense, but in the rarer, more valuable sense. She had a voice that sounded like a person, not a performance. Warm and a little rough at the edges, instantly recognizable from the first note. By 1967, they were earning enough to buy a house in Bel Air. By 1968, they were appearing in films. By 1971, they had their own television program, the Sonny and Cher Comedy Hour on CBS, and it changed everything again. The show ran from 1971 to 1974, and at its peak drew approximately 30 million viewers per episode. 30 million people every week, sitting down to watch Sonny play the lovable fool and Cher play the woman who was too smart, too beautiful, and too funny to suffer him gladly. It was a comedy built on the most durable of all comedic premises, the fundamental incompatibility of two people who love each other anyway. And it worked, in part, because it was not entirely fiction. Their daughter, Chaz Bono, was born in 1969. The family was complete, at least on paper. The show was a hit. The records were still selling. The brand, and by this point it was a brand, carefully managed and commercially sophisticated, was worth millions. And then it stopped working. Not the money, not the fame, the marriage. Cher has been asked about the end of her marriage to Sonny more times than any reasonable person should have to answer a question. And her answers have changed over the decades as she has changed, softened in some places, sharpened in others, but always returning to the same fundamental truth. She had outgrown something, or perhaps she had grown into something that the structure of that marriage could not contain. She was not, by the early 1970s, the 16-year-old girl from El Centro who had been grateful to be seen. She was one of the most recognizable women in America. And she knew it. They separated in 1974. The Sonny and Cher comedy hour ended. The divorce was finalized in 1975. And then came the agreement that would sit quietly at the center of a legal earthquake for the next half-century. On August 10, 1978, 3 years after the divorce was finalized, Cher and Sonny signed a formal divorce settlement agreement. The terms were specific and consequential. Cher would receive 50% of the royalties from Sonny's compositions, 50% of the royalties from the recordings they had made together. I Got You, Babe, The Beat Goes On, Baby Don't Go, and the others. The agreement was governed by California state law. It was, in the language of family law, a marital settlement agreement, a binding contract between two people who had been married, dividing what they had built together. It was not a gift. It was not generosity. It was a legal recognition that what they had made together. That the voice on those records and the name on those albums belonged to both of them, and that the money those recordings continue to generate belonged to both of them as well. 50% in perpetuity, for as long as the songs existed and earned. Sonny agreed to those terms. He signed the document, and for the next 20 years, the arrangement held, quietly, without drama, a piece of legal paperwork filed in a California courthouse that almost no one outside of their respective legal teams knew or thought about. Sonny moved on. He remarried Mary Bono in 1986, a woman 22 years his junior, who was working as a fitness instructor when they met. They had 2 children together. Sonny entered politics, serving as mayor of Palm Springs from 1988 to 1992, and then winning election to the United States House of Representatives in 1994. He was, by the mid-1990s, a congressman. The boy from Detroit, who had once been a promotion man at a record label, was now making federal law. Cher, meanwhile, had rebuilt herself so completely that the Cher of the late 1970s bore almost no resemblance to the Cher of the 1960s. In sound, in image, in ambition. She had launched a solo career of genuine artistic seriousness. She had pursued acting with the kind of commitment that forces critics to revise their assumptions. In 1988, she won the Academy Award for Best Actress for Moonstruck. Not a Golden Globe, not a nomination, the Oscar. At 41 years old, the girl who had struggled to read in school stood on the stage of the Dorothy Chandler Pavilion and accepted the highest individual honor in American cinema. And in 1998, at 52 years old, she released Believe, a song that used pitch correction technology in a way no mainstream artist had attempted before, that spent 7 weeks at #1 in the United Kingdom, that became one of the best-selling singles in the history of recorded music, and that introduced her to an entirely new generation of listeners who had not been born. When I Got You Babe was a hit. 2 careers, 1 name, 50% of a set of songs sitting in a filing cabinet somewhere, quietly accumulating royalties. What happens when someone decides, 40 years after the ink dries, that the agreement no longer applies? Sonny Bono died on January 5, 1998. He was skiing at the Heavenly Mountain Resort near South Lake Tahoe, Nevada, a run he had taken before, on a mountain he knew. He struck a tree. He was 62 years old. The death was ruled accidental. The shock was immediate and national. A congressman, a former pop star, a man who had spent 3 decades being underestimated and had spent those same 3 decades proving the underestimation wrong, was gone in an afternoon on a ski slope. Cher spoke at his funeral. She stood at the podium and said the things that only she could say about him. Not the things a former spouse is expected to say, but the true things, the complicated things. The things that acknowledged that their story was not reducible to a marriage that ended or a television show that was canceled. She called him the most unforgettable character she had ever met. She said that he had made her who she was. She said it without bitterness and without performance, in the flat, direct register that has always been the most honest version of her public voice. It was a eulogy that reminded everyone watching that whatever had happened between them, and a great deal had happened between them, the connection was real, and the loss was real. And the 50% on a piece of paper signed in 1978 was not the most important thing that had ever existed between Sherilyn Sarkisian and Salvatore Bono. But the piece of paper still existed. Mary Bono, 40 years old at the time of Sonny's death, married to him for 11 years, mother of his 2 younger children, became the executor of his estate. She was, by all formal and legal measures, the person responsible for managing what Sonny had left behind. That included his political legacy. She was elected to Congress in a special election in April of 1998 to fill the seat he had vacated by dying. And she served in the House of Representatives until 2012. It included his personal assets, and it included his intellectual property. The songs, the compositions, the recordings, the royalties that those recordings continued to generate year after year as licensing deals and streaming platforms and television placements kept I Got You Babe alive in the culture. For the first 20 years after Sonny's death, the arrangement held. The royalties continued to flow. Cher received her 50%. The marital settlement agreement of August 10, 1978, functioned exactly as it was designed to function, quietly, automatically, without drama or dispute. 2 decades passed. The music industry changed beyond recognition. Streaming replaced physical media. Licensing revenue from film and television placements became increasingly significant. The songs that Sonny and Cher had recorded in the 1960s did not become less valuable as the years accumulated. If anything, they became more valuable, because nostalgia is an industry, and 1965 is a very marketable year. And then, in 2018, something changed. Not in the music, not in the money, in the law. The termination rights provision of the United States Copyright Act, a federal statute designed to protect creators and their heirs from having signed away rights under contracts that, over time, proved to be grossly unfair, became applicable to a specific category of works first published in the late 1960s. The law allows creators, or their heirs, to reclaim rights that were previously assigned or licensed, regardless of what the original contract said. The intent of the provision is protective, a recognition that a songwriter in 1965 could not have anticipated what their music would be worth in 2020, and that the contracts signed in that era should not be allowed to bind heirs forever if those heirs choose to reclaim what was created. Mary Bono's legal team identified this window. They concluded that certain of Sonny's publishing rights, the rights to his compositions, including the compositions that had been assigned to Cher under the 1978 divorce settlement, were now eligible for termination under federal copyright law. Mary filed termination notices with the relevant publishers. The notices stated her intention to reclaim those rights, including the 50% interest that had been granted to Cher more than 40 years earlier. The legal argument was not frivolous. Federal copyright law does, in certain circumstances, allow termination of prior grants, even grants made in contracts that both parties signed willingly. The question that would eventually consume 5 years of litigation, more than $1 million in legal fees, and the attention of a federal judge in Los Angeles, was whether federal copyright law could be used to override a California state marital settlement agreement. Whether a statute designed to protect creators and heirs could be deployed to strip a former spouse of rights that a court had awarded her as part of a divorce. Whether, in other words, what a federal law giveth, a federal law could taketh away from someone who had received those rights not as a creator or an heir, but as a wife. Cher's legal team saw the termination notices and understood immediately what was at stake. This was not a dispute about interpretation. This was not a misunderstanding between parties who shared an interest in resolving things quietly. This was a direct challenge to the enforceability of a 40-year-old agreement, an agreement that had been generating income for Cher for 4 decades, an agreement that she had every reason to believe was permanent and unassailable. The clock that had started ticking on January 5, 1998, the moment Sonny died and Mary became the person in charge, had been running quietly for more than 20 years. In October of 2021, it stopped being quiet. In October of 2021, Cher filed suit against Mary Bono in the United States District Court for the Central District of California. The complaint was specific and the damages were quantified. Cher was seeking $1 million. She was alleging that Mary Bono had improperly used the federal termination rights provision to attempt to eliminate rights that had been granted to Cher, not as a work-for-hire assignee, not as a publisher, not as any of the categories of rights holder that the termination statute was designed to address, but as a former spouse under a California state marital settlement agreement that had been signed by both parties, approved by a court, and honored without interruption for more than 4 decades. The core of Cher's legal argument was elegant in its simplicity. Federal copyright law exists. California family law also exists. They govern different things. The termination rights provision was written to allow creators and their heirs to reclaim rights that had been assigned away in commercial transactions, not to allow widows to strip former spouses of assets that a divorce court had already distributed. The 1978 agreement was not a publishing contract. It was not a licensing deal. It was a marital settlement, a different instrument entirely, governed by a different body of law, operating in a different legal universe. And federal copyright law, Cher's team argued, had no authority to reach into that universe and undo what California family law had already settled. Mary Bono's legal team argued the opposite. The termination rights provision, they contended, was broad and intentional. Congress had written it without carve-outs for marital settlements. If the statute allowed termination of prior grants, it allowed termination of prior grants, including those made in the context of a divorce. The fact that Cher had received the rights as part of a divorce settlement did not, in their view, remove those rights from the statute's reach. The law was the law, and the law said these rights could be reclaimed. Federal Judge John A. Kronstadt a Barack Obama appointee who had been on the Central District Bench since 2011, was assigned to the case. He was not, by reputation, a judge who moved quickly or decided carelessly. He was methodical, he was thorough, and he was about to spend the better part of 4 years working through one of the more genuinely novel questions in American copyright law. The litigation proceeded through the standard sequence of federal civil practice: motions, discovery, briefings, oral arguments, at the pace that federal litigation moves, which is to say slowly and expensively. 2022 passed. 2023 passed. The royalties continued to be disputed. Mary Bono's position was that the termination notices were valid and that Cher's interest in the publishing royalties had been extinguished. Cher's position was that the notices were legally meaningless as applied to her, and that the withholding of royalties was a breach of the 1978 agreement. Then, in May of 2024, Judge Kronstadt issued his first major ruling. He found in favor of Cher. Specifically, he held that she was entitled to more than $418,000 in royalties that had not been paid since July of 2022. Royalties that Mary Bono had withheld on the basis of the termination notices. The judge's reasoning was clear. The termination notices, whatever their validity in other contexts, did not have the legal force to override a California marital settlement agreement. The money that had been withheld was owed. It needed to be paid. It was a significant victory. But it was not the final ruling. The core question, whether Mary Bono's termination notices had permanently extinguished Cher's rights, or whether those rights would continue in perpetuity regardless of the notices, had not yet been definitively resolved. The May 2024 ruling addressed the back royalties. The question of the future royalties and of the fundamental enforceability of the 1978 agreement going forward remained open. Cher and her legal team continued. Mary Bono and her legal team continued. The fees accumulated on both sides. The question of who would ultimately bear those costs, an issue that would become the subject of its own separate ruling almost 2 years later, was already beginning to take shape in the background, a financial subplot running parallel to the main legal drama. And then, on November 26, 2025, the day before Thanksgiving in the United States, Judge Kronstadt issued his final ruling on the merits. The decision was comprehensive and unambiguous. Cher maintained the right to receive 50% of the royalties from Sonny Bono's compositions in perpetuity. Mary Bono's termination notices had not terminated and had not in any way affected the marital settlement agreement of August 10, 1978. The judge was explicit on this point. The notices were legally inoperative as against Cher's rights under the divorce settlement. They could not reach what California family law had already distributed. Federal copyright termination rights, as written and as intended, were not a tool for undoing the financial terms of a divorce. Additionally, the judge ordered that Cher be paid more than $187,000, plus interest, in publishing royalties that Mary had withheld in violation of the agreement. The money was owed. The agreement was enforceable. The attempt to void it had failed. It was, by any measure, a decisive win for Cher. 5 years of litigation. Hundreds of thousands of dollars in legal costs. A federal judge in Los Angeles who had worked through the question with the care it deserved and arrived at a conclusion that was, in the end, grounded in a principle that seemed almost commonsensical once stated plainly, that a law designed to protect creators from unfair commercial contracts cannot be repurposed to strip a former spouse of assets that a divorce court awarded her nearly 50 years ago. Mary Bono announced that she would appeal. The battle, she indicated, was not over. The November 2025 ruling was not the end of the story. It was the end of one chapter, and the beginning of another that had not yet been written. But Cher had won the central question. The royalties were hers. They had always been hers, and a federal judge had now said so in terms that left very little room for ambiguity. What she did not yet know, or perhaps what she knew all too well, because she had been paying legal bills for 5 years, was that winning the war would not mean walking away from it free. On July 17, 2026, Judge John A. Kronstadt issued his ruling on attorneys' fees. Cher had asked the court to order Mary Bono to pay her legal bill, $1,023,605.30, the precise accumulated cost of 5 years of federal litigation conducted on her behalf by a team of attorneys who had argued, briefed, motioned, and appealed their way through one of the more consequential copyright cases of the decade. She had won the underlying case. She had won on the merits. She had won comprehensively. And under certain provisions of federal law, a prevailing party in a copyright dispute can recover attorneys' fees from the losing side. Judge Kronstadt denied the request. His reasoning was careful and, in its way, entirely consistent with the logic that had governed his rulings throughout the case. The central legal question in the litigation, whether Mary Bono's termination notices could override the 1978 marital settlement agreement, was primarily a question of contract law, California contract law, state family law, not federal copyright law. The attorney's fees provision that Cher had invoked applied specifically to cases decided under the Federal Copyright Act. And while the Copyright Act was the instrument Mary Bono had attempted to use, the case had ultimately turned on state law contract principles, not on the interpretation of federal copyright doctrine. The fee-shifting provision did not apply. Cher would pay her own legal fees, $1,023,605.30, out of her own pocket. For winning, it is the kind of outcome that produces a particular, vertiginous feeling. The feeling of having been entirely right about something enormously important, and of discovering that being right does not insulate you from the cost of proving it. Cher did not lose the royalties. She will continue to receive 50% of what those songs earn for as long as they earn anything. I Got You, Babe will continue to play in films and television programs and streaming playlists and wedding receptions and every other venue where a particular vintage of American popular music is considered essential. The Beat Goes On will continue to exist. Baby Don't Go will continue to exist. The money will continue to come. But the $1 million is gone. And she spent it herself to keep what was hers. Mary Bono has announced her intention to appeal the November 2025 ruling on the merits, the ruling that confirmed Cher's rights in perpetuity. That appeal has not yet been decided. The case that Judge Kronstadt spent 4 years resolving at the district court level will now move, at least in part, to a higher court. The question that seemed settled on the day before Thanksgiving in 2025 is, in a legal sense, still open. Mary Bono's position that federal copyright termination rights can reach the financial terms of a state marital settlement agreement has not been accepted by any court, but it has not been reviewed by an appellate court either. The argument continues. For Cher, the July 2026 ruling landed against the backdrop of a year that had been, by any reasonable measure, extraordinary. In February of 2026, she accepted the Lifetime Achievement Award at the Grammy Awards, the Recording Academy's highest honor, the kind of recognition that is given not for a single achievement, but for the sum of a career, for the accumulated weight of decades of work that changed something. She stood on that stage at 80 years old and received it. She appeared at the Met Gala in 2026. She remained, as she has remained for 60 years, entirely, unmistakably present. At the same time, a separate legal matter involving her son Elijah Blue Allman, her child from her marriage to musician Greg Allman, was moving through the California courts on its own separate track. Elijah Blue has alleged that Cher stopped providing him with regular financial support in August of 2021. The same month, notably, that the royalty dispute with Mary Bono was escalating toward litigation. Cher made multiple attempts to obtain a legal conservatorship over Elijah Blue, arguing in court filings that he lacked the capacity to manage his own financial affairs. The most recent of those conservatorship petitions was denied without prejudice in April of 2026. Elijah Blue receives $10,000 per month from the trust established by his late father, Greg Allman, and is separately engaged in his own legal proceedings regarding spousal support he pays to a former partner. The conservatorship matter remains unresolved. It is a portrait of a life that does not simplify as it accumulates. At 80 years old, Cher is simultaneously a Grammy Lifetime Achievement honoree and a federal court litigant. She is simultaneously a woman who just won a landmark copyright case and a woman who just received a ruling telling her she has to pay $1 million for winning it. She is a mother engaged in difficult, public, legally contested relationships with her children. She is an icon whose cultural presence is so durable and so total that it sometimes obscures the fact that the person inside the icon is navigating the same complicated terrain: family, money, legacy, loss, that everyone eventually navigates, just with more lawyers and more cameras. The songs are still hers. That is not a small thing. In the ecosystem of music publishing, 50% of the royalties from a catalog that includes I Got You Babe is not a symbolic victory. It is a continuing, compounding, financially significant asset. Every time that song is licensed, every time it is streamed, every time it appears on a soundtrack or a commercial or a television program, Cher receives her half. That will continue. The agreement of August 10, 1978, signed by two people who had just ended their marriage and were trying to divide what they had built, will continue to function exactly as it was designed to function. Sonny gave her 50% of everything in 1978. His widow said in 2018 that she was taking it back. A federal judge said in 2025 that she could not. A different federal judge said in 2026 that Cher still had to pay the bill herself. She won. She pays. She keeps going. That is not a metaphor. That is the literal, documented, legally verified sequence of events in the life of Sherilyn Sarkisian in the year 2026. And it is, in its way, the most Cher thing that has ever happened. Because the most Cher thing that can happen is that she wins something that cost everything, and then gets up and keeps going anyway, because stopping was never actually on the table. What does it mean to fight for something for 5 years, spend $1 million, win every ruling that mattered, and still walk away holding the bill? And more than that, what does it tell us about the value of holding on to what is yours, even when holding on costs more than walking away ever would have? There is a version of this story that ends with a lesson about the law, about how federal copyright termination rights were designed to protect creators and their heirs, and how that protection has limits. Limits that a federal judge in Los Angeles spent 4 years identifying and articulating. Limits that were written into the structure of American law long before anyone imagined they would be tested by a dispute between a pop star's widow and a pop star's ex-wife over songs recorded in 1965. That version of the story is accurate. It is legally precise. It is the version that will be cited in law review articles and copyright textbooks and appellate briefs for years to come. But it is not the whole story. The whole story is about a girl from El Centro, California, who left at 16 with nothing and spent the next 64 years refusing, with a consistency that borders on the geological, to be told that something she had earned was no longer hers. The whole story is about a voice that was present on I Got You, Babe in 1965, and present on Believe in 1998, and present on the stage of the Grammy Awards in February of 2026, when the Recording Academy placed a Lifetime Achievement Award in her hands and acknowledged, formally and finally, what the culture had known for decades. The whole story is about what it costs to be Cher. Not in the glamorous sense, not in the wigs and sequins sense, but in the specific, grinding, legally documented sense of a woman who has spent her entire adult life fighting for the right to keep what she built. She built it with Sonny. That is also part of the whole story, and it is the part that the legal proceedings, with their notices of termination and their fee-shifting provisions and their careful distinctions between state contract law and federal copyright doctrine, cannot fully contain. They made those songs together. He wrote them. She sang them. The world received them as a unit, and when the marriage ended, the law of California said that what they had made together belonged to both of them, in equal measure, for as long as the music existed. Sonny agreed to that. He signed it. Whatever complications existed between them, and there were complications across years and subsequent marriages and diverging careers, and the particular unresolvable complexity of two people who had been everything to each other before they were nothing to each other, he agreed, on August 10, 1978, that 50% of what they had made was hers. That agreement held for 47 years. It survived Sonny's death. It survived a congressional career and a second marriage and a 20-year period of quiet royalty payments and a copyright statute, and 5 years of federal litigation and 2 separate rulings by a federal judge and an announced appeal that has not yet been heard. It is still holding. It will continue to hold until an appellate court says otherwise, and no appellate court has yet been persuaded to say otherwise. Cher is 80 years old. She has an Academy Award and a Grammy Lifetime Achievement Award and an Emmy and a catalog of recordings that spans 6 decades and a legal victory that cost her $1 million and is not yet entirely final. She has a son whose relationship with her is being conducted, at least in part, through the California court system. She has a cultural presence so deeply embedded in the fabric of American popular life that it is almost impossible to imagine the landscape without it. She appeared at the Met Gala in 2026. She will almost certainly appear somewhere else next month, and the month after that, and the month after that. Because disappearing is not something she has ever been particularly good at. And at this point in her life, it seems unlikely she is going to start. The appeal is coming. Mary Bono has said so, and there is no reason to doubt her. The question that Judge Kronstadt answered in November of 2025, whether federal copyright termination rights can reach the financial terms of a state marital settlement agreement, will be reviewed by the Ninth Circuit Court of Appeals, and that court may agree with Kronstadt, or it may not, and if it does not, the litigation that has consumed 5 years and $1 million will continue into its next chapter. Nothing in the legal world is truly over until every court that can speak has spoken. But here is what is true right now, on July 22, 2026, as this story is being told. A federal judge looked at the question and said the agreement held. A federal judge looked at the royalties and said they were owed. A federal judge looked at the termination notices and said they could not reach what California family law had already settled. And a different federal judge looked at the attorney's fees and said Cher would pay them herself. Because winning a contract case, even a contract case that touched federal copyright law, does not entitle the winner to shift the cost of winning onto the loser. She won. She pays. She keeps going. If that sounds familiar, if it sounds like the summary of a career as much as the summary of a lawsuit, that is because it is both. It has always been both. The specific legal mechanism changes. The underlying dynamic does not. Cher wins things that cost everything. And then she gets up. And then she keeps going. Because the alternative, stopping, retreating, accepting the version of events that someone else is trying to impose, has never been an option she recognized as real. I Got You. Babe was recorded in 1965. It will be playing somewhere in the world tonight, and tomorrow, and the day after that. 50% of whatever it earns belongs to Sherilyn Sarkisian. It always has. A judge just said so, and $1 million says she was right to make sure of it. If this story has stayed with you, if the image of an 80-year-old woman spending $1 million in a federal courtroom to hold on to what was hers since 1978 tells you something true about what it means to fight for your own legacy, leave a tribute below for Cher, for the voice that was there in 65, and there in 98, and there in 2026, for the woman who has never once mistaken winning for ease. What would you have done? Walked away from the royalties or spent the $1 million? And what does the answer say about the price of standing your ground? If you want more stories like this one, stories about the battles behind the fame, the legal wars behind the legacies, the real cost of the lives we watch from a distance, subscribe to Golden Fame News. We will be here. And so, it seems reasonable to assume we'll share.